talk, whether the diagnosis was that she's in the terminal stage, she wouldn't last much longer. Her roommate, according to that story, her roommate went over to her and said, "Carrie, they're about to do you in. You better get up." At which point she pops up. She's ready to eat again. And these estimates have been steadily unreliable. But years ago at Illinois, giving a talk at the University of Illinois, a lovely nurse, Eileen Brown from Washington State, came up to recognize the force of what legs are imparted once you establish that there is a right to assisted suicide. It dawned on her after my talk that she had these patients with AIDS who wanted to have a recognized right to end their lives because they were afflicted with AIDS. Once you establish there's something rightful about it, there's a right to do it, then of course the decision could be transferred to substantive judgment. When a patient wasn't in a position to render his own judgment, you transfer the judgment to a relative. You've already established there's something rightful about ending the life of someone with that affliction. And if that person doesn't happen to have a relative, well, my goodness, how could you allow him to be deprived of this good? Merely because there isn't a relative, so the right is then transferred to an administrator in the hospital. So something that begins as a right for the person is transferred to a relative, then to a stranger who can make that decision. But there's something quite portentous about moving to the level of a right to do oneself. I recall my friend Gil Meilander in Villanova saying, after many years of picking up toys, driving kids to soccer games and Little League baseball, and taking them to all their lessons, I mean to be a burden in my old age. Well, I was asked to talk about this vexing matter as we're all waiting for the court to come out with a judgment on Obamacare, but I attempted to tell a story I used at Dagawam about a month ago. It's never out of season to recall this story. It's an old story about a man living in a Victorian house. And the bell rings one day, and it's a gal of college age doing some work to make money for college. And he says, well, I wanted to do the porch. I got to pay her. How about $50 to do the porch? She says, fine. Goes in and tells his wife, and she said, did you tell her that porch wraps all around the house? Well, let's see what she does. An hour later, the bell rings, goes to the door. She's done. I said, done? 1 hour? Oh, she said, it was a snap. I gave her 2 coats. And by the way, it's a Lexus, not a Porsche. So the lesson is listen carefully. Now, as I said, we're meeting at a time of waiting, a time that figured to be far more anxious several months ago than it is today. But we can't be entirely delivered from anxiety as long as we have on the court that bundle of passions and soaring ego known as Anthony Kennedy. And after the oral arguments before the Supreme Court, it's claimed that a cluster now of about 5 Republican judges bore the deepest anxiety about the rationale that could support the constitutionality of that vast scheme known as Obamacare. Now, we can't be sure that the most schooled followers of the court on our side, and I happen to know 2 of the 3 men who argued on our side before the court that day, Mike Carter and Greg Katsas, the most schooled followers of the court on our side seem to think that the prediction is slightly tilted in our favor. The expectation is that the court will probably strike down Obamacare, perhaps on a vote of 5-4, perhaps even 6-3 if we can snare Mr. Justice Breyer. But only a few months ago, there was a genuine worry about my friend Justice Scalia. I was at Harvard doing a talk in February, and I had dinner with 2 friends, Mary Ann Linden and Judge Edith Jones, if I used to. And she said, Edith Jones said, and I agree, we couldn't be sure where Scalia would come down. And that uncertainty is the key to the law that's been built up over the Commerce Clause over the last 75 years since the New Deal. The conservative judges, such as Scalia and Rehnquist, shown their conservative past in part by their willingness to avoid unsettling the law, to for their willingness to sustain the precedents from the past and make only the slightest alteration. It used to be said that a conservative judge will alter the law the way one alters the delicacy of a hanging mobile, making only the slightest changes that would not unsettle things on a vast scale. As recently as 5 years ago, in the Rake case on marijuana from California, Scalia wrote for the court in sustaining a plenary exclusive authority for the federal government in dealing with the regulation of drugs or controlled substances. And when he did that, he confirmed yet again, confirmed the lines of doctrine under the Commerce Clause that the liberal side would invoke in the defense of Obamacare. The Obama administration and its allies didn't seem to suffer the least doubts that the rationales settled from the past under the Commerce Clause would readily hold and even sustain this mammoth extension of controls under the Patient Protection and Affordable Care Act, also known as Obamacare. And I must admit that since Scalia affirmed the main lines of that jurisprudence as recently as 2007 in the Rake case, he was on the surface quite conceivable, quite consistent with his character, and quite consistent with the jurisprudence he sought to represent. If he could say, look, this is not a result-oriented jurisprudence. We're respecting the lines of jurisprudence we put in place. This may be an objectionable law, but you're going to have to defeat it politically. Don't ask the judges to get in and do your political work for you, and I just show you how apolitical I am as a judge. Quite conceivable. At the oral argument, though, Scalia was highly critical of the argument put forward in defense of Obamacare, and he joined his colleagues in putting that critical question to the government: if we can sustain this reach of the federal authority in virtually commandeering, commanding all persons in the country, even youngsters, healthy people, to buy this private product, this medical insurance, and put themselves under this vast, far-reaching federal regulation. If the federal government could do that, would you tell us what the limiting principle is? Would you tell us what the federal government cannot reach? And of course, the Solicitor General could not come up with the answer to that question. As the Chief Justice, John Roberts, suggested, it could be a potent support to health care and preservation of life if everyone carried a cell phone. And so could the federal government command everyone to buy a cell phone. And so could the federal government give that vast business to Verizon and others and have the federal government stipulate the features of that phone plan. And my friend Sam Alito observed that just as everyone will need medical care, everyone will need a funeral. And so could we command people to buy sort of burial insurance in order to relieve their families of the strain that may come about during death? And yet, as I say, if we understand the governing doctrine or the rationale of the Commerce Clause, we remind ourselves just why the liberal side could have been plausibly confident that Obamacare would sail through, and we still don't know that it won't. In fact, a couple of accomplished federal judges, including Larry Silverman, the District of Columbia Court, D.C. Circuit, and a very dear friend of Nino Scalia's. Larry Silverman was quite apt. In fact, Randy Barnett, who's working on the case, he was encountered by Larry Silverman at the parking lot of Georgetown Law School. Larry Silverman was haranguing him on why this must be constitutional. Larry Silverman was quite adamant in arguing this was indeed a political matter, that the constitutional lines were essentially settled. This was one of the most conservative judges in the country. What Larry Silverman was relying on, along with the liberals, was that infamous case in 1942 of Wickard versus Filbert. That's going to be an unfortunate cookies throughout the country. In that case, the court sustained the government when it sought to bar Roscoe Filbert, a farmer in Ohio, from setting aside for the use of his own family the portion of the wheat grown on his own farm. As the rather urbane Justice Robert Jackson explained, if every farmer, it seemed innocent in itself, but if every farmer claimed the right to do those many private acts, aggregate, could undermine a scheme that required the regulation of the national production of wheat. And very simple would argue, look, if you're telling Roscoe Filbert can't put aside that wheat, you're virtually forcing him into the market to buy wheat. To which Mike Carvin argues in his brief before the Supreme Court, yet that if he doesn't want wheat, you can compel him to buy the wheat. He may decide he doesn't want wheat. Now you are compelling somebody to have the wheat. Now, this kind of argument would be used later in sustaining the Civil Rights Act of 1964, in a case called Katzenbach versus McClung. And it ran in this way, that if black people face discrimination as they travel in interstate commerce, face the prospect of being denied rooms in hotels and service in restaurants, there'd be fewer people, black people traveling in interstate commerce. If that were the case, there'd be fewer orders for meat, for linens, silverware. And so this is having a vast effect in depressing interstate commerce. So you want to know what's the wrong done to black people? You're interfering with the interstate flow of meat. This is how the schemes work under the Commerce Clause. Now, all of this was done on the force of conjecture alone. Nobody took any evidence as to how many black people were, in fact, discouraged from traveling. I drive down from Amherst, go through 5 states to reach D.C., and I don't stop for any of the food and restaurants along the way. And Larry Tribe, Professor Tribe at Harvard, would draw precisely on the same cast of the argument in the early 90s as he sought to make the case for the Freedom of Choice Act to enact Roe versus Wade into a statute. And one of the beckoning features of this argument for Tribe was that there was no need to supply any empirical evidence. He simply posited the claim that if some states were allowed to enact restrictions on abortion, there'd be a larger number of people on the highways driving to places where it was allowed. And there'd be more accidents on the highways, and we'd have, as he said, highways of anguish as people were driving out. But to take it even more sober view, we need to remind ourselves that with the Civil Rights Act of 1964, the federal government had penetrated deeply into the ordering and regulation of the private sphere. It told people who were quite unwilling to have commerce with black people that they had to engage with those black people if they wished to stay in business. But when Congress was extending this legislation in the 1960s, Gerhard Casper at the University of Chicago registered the point that there was a strange view of rights, that I have a right to compel an unwilling vendor to sell me something or to engage with me. I mean, if I had a property right, it should be right over my control over that property. Now, compared with that, requiring people, if they're a business, to have commerce with people they have no interest in having any dealing with, compared to that, forcing people to buy something, even a medical policy, no longer seems such a dramatic novelty or a big deal. And so when we set that policy against the implications that were recognized at the very beginning in 1937, when the jurisprudence of the Commerce Clause was changed, the requirement simply that people buy something, some rather pales in significance, and somehow it loses its capacity to shock. The implications of that shift in 1937 were drawn out with a jarring simplicity. I hope you forgive me if I just take a little detail to recall what the lay of the land was in this jurisprudence back then. The implications were drawn out with a simplicity and directness by Justice James McRennan. It's a rather awful man. In his dissenting opinion in the labor board cases. At issue in those cases was the claim of the federal government to impose unions with closed shops on private companies. And one of the cases involved a factory in Richmond dedicated to the manufacture of men's clothing. The argument for the authority of the government to impose a union on private business moved through a chain of predictions, all quite problematic. If we didn't have a union, there'd be a strike. If you had a strike, the business would be closed, the production stopped. It would be an interference with the flow of interstate commerce. And so the firing of only 29 employees out of a force of 800 employees in a factory that accounted for 0.5% of the men's clothing in the country, this was seen as one of those dramatic stoppages of the flow of commerce, as they created new authority for the federal government in stipulating the conditions and imposing a union on a private company. Once that kind of proposition was in place, it was simply a matter of delicacy to hold back from making starkly explicit the implications that flowed from that argument. Justice McReynolds' cantankerous emphasis of that character was never supplied with delicacy. And so he suffered no inhibitions about making the argument. He said, he asked, may a mill owner be prohibited from closing his factory or discontinuing his business because to do so would stop the flow of products from his company? May employees in the factory be restrained from quitting work in a body because this will close the factory and stop the flow of commerce? May arson of a factory be made a federal offense whenever this would interfere with the business? If the business cannot continue without the existing wage scale, could the federal government command a lowering of the wages? He's drawing out all the implications of this extension. And of course, the other common sense implication was, why not just ban the strike itself? If that's what would cause the interference with the flow of commerce. But McReynolds himself was so aghast that he thought that he had done the shocking work here simply by drawing out the implications. He apparently assumed that these implications would be staggering enough to sort of hold people off. But with that move, he touched the deepest axioms of personal freedom, the axioms that ran back to the working judges who had come out of the anti-slavery movement, and pointed to a deeper argument, the argument that I preferred in these cases that I've written about in First Things, the December issue, to consider the argument not about the Commerce Clause, but as a matter of natural right. William Nelson at Harvard reminded us a while ago the way in which the resistance to compulsory unions came out of the work of those judges who came out of the anti-slavery movement. And the most telling sign came when those threads were brought together by Justice John Harlan, the famous dissenter in Plessy versus Ferguson on segregation of railways. And the argument ran essentially in this way. It dealt with the premises that rejected slavery. And it ran this way, that no man was by nature the ruler of other men. A man's labor belonged to himself, as he belonged to himself. And so no man had an obligation to justify himself when he walked off a job or left the employ of any other man. But on the other side, the employer was every bit as much of a natural person as the employee, with no lesser claim, no lesser natural right to his own liberty of association. Now, workers surely have the right, implicit in their standing as free men, to join other workers in the same workplace, to insist that they won't work for anyone who didn't hire their friends. But to say that they have the power also to deny work in the company to people who were not part of the union, that was a major step that was inconsistent with the deep premises of personal freedom and the anti-slavery argument. As Harlan explained, the employer must have this right to his own freedom of association, which entailed the right to quit his association with any workers who were governed by that kind of a code. Employees who would actually claim the power to deny work to other men and deny to the owner his right to his own association for his own legitimate end of keeping that business going. Now, McReynolds had an argument that went right around the Commerce Clause. You know, the argument didn't deal with it dealt with the deep axioms of personal freedom. That was the way to counter this move to extend the Commerce Clause. And that's what I've taken my own lead from that kind of an argument. My own position is that the argument against Obamacare should be made on the same grounds. And I've already seen the signs that people on the left show a willingness to make precisely that kind of an argument for defending Obamacare when they're pressed. And the deeper truth right now concealed, may emerge more readily if I recall an argument that I made here. in a lecture I did at the Supreme Court Historical Society back in the mid-90s, where Mr. Rehnquist, then Chief Justice, did the nice deed of introducing me that night. And he sort of lit up when I offered this argument. I remarked in my lecture to the court that the conservatives have never been able to talk the liberals out of this extended reach of the Commerce Clause. Yet we find jurists willing to overthrow the doctrines of a lifetime when they collide with that vaunted right to abortion, which seems to have replaced freedom of religion and freedom of speech as the first freedom for many of these people. I mean, I was in the courtroom that day in 1986 where Thurgood Marshall discovered states' rights. Oh my God. Reagan administration was trying to get access to the records of a hospital to find out the grounds from which medical care was withdrawn from this newborn afflicted with spina bifida and Down syndrome. And here Thurgood Marshall was arguing for years against discrimination in hospitals. Now suddenly discovers a states' rights and the insulation of hospitals from the reach of that law. I drew upon the logic of Wickard versus Filburn, and I offered this construction, which sort of lit up the Chief Justice's eyes. I said that under the doctrine of Wickard versus Filburn, why couldn't we argue in this way? That singular, private abortion may be yours alone, but when it is abrogated with 1.2 million each year, it is having the most profound, vast effect on the interstate sales of diapers, baby food, bassinets, weddings, bar mitzvahs, college educations, to say nothing of 1.3 million people coming on every year as taxpayers to sustain the Social Security system. Now, I'd submit to you that this argument fits not only plausibly, but compellingly under Wickard versus Filburn. If you would take that seriously, as Larry tried with it, we could make this argument. But when we do, it's interesting to know how the other side reacts. Larry Tribe would say, oh, but you're dealing now with a deep matter of personal freedom and privacy. Right? It has nothing to do with the Commerce Clause, the axioms of freedom. And when this argument was raised, just before the argument, the discussion with Mike Carvin and Neil Kinkow, arguing for the Obamacare, Mike R. Carvin said, why can't the government force us to eat broccoli? Because it would be good for our health. And Neil Kinkow said, that interferes with deep matters of privacy and the Bill of Rights. Right. Well, there's nothing about privacy in the Bill of Rights, and nothing in the Bill of Rights about the government compelling us to buy a product we're disinclined to buy. But notice that his move was to deep premises of personal freedom, axioms of freedom, that had nothing to do with fitting this into the grooves of the argument over the Commerce Clause. And so the question is, how might that argument be made as a matter of natural right? I think not by insisting that we have a natural right not to be coerced into buying things that we have no wish to buy, but by pointing out that this scheme of national medical care is virtually bound to produce a scheme of rationing, as has produced that rationing in Britain and Canada, a scheme of denying medical care to people who may have become now entirely reliant on the government for the funding and provision of their care. And under the system of nationalized care, the government is bound to deny treatment, as the government in England routinely denies treatment under the National Health Service. And we now have in place the scheme for the commissions of unelected people wielding vast discretionary power, said to be loosed entirely, detached entirely from the tethers of restraint in 2019, commissions with this vast discretion, likely to do the same rationing now done by comparable commissions in Washington State. The New York Times reporter John Burns remarked that his son, born at the weight of only 1 pound, would not have been given in England the life-sustaining treatment that brought him through in the United States. I know myself people in the 80s on dialysis in this country, a procedure that would be denied them in England, as far as I understand. And the denial of the care, when it comes, will not be the denial coming from an insurance company under arrangements that people have chosen for themselves and with schemes of appeal, which some of these decisions have been outdone. It would come from an agency, it exercises the monopoly powers of law. And the possibility of seeking an overturning of that decision within the Obama bureaucracy would be rather an experience out of Dickens. So it may make the most notable difference that the denial treatment would be coming from a government that may have now, as I say, the monopoly power to withhold that medical care that seems to any person necessary in preserving his life. That is a right on the part, to be more precise, the right of an innocent person to seek the preservation of his own innocent life through means that are thoroughly legitimate, involving no threat to others and no moral injury sustained to himself. When you take it to that level, I think there's a rather firm axiom of personal freedom that comes into place here. Comes into play quite apart from the formulas that become familiar under the Commerce Clause. Now that, I say, is the kind of argument that might be drawn on the ground of natural right. It's the style of argument, as we've seen, that the liberal side would have no hesitation using to defend its position. But it's the conservative lawyers who have now schooled themselves into an aversion to any argument that seems to smack of natural rights and natural law, and schooled themselves to the point where they no longer even understand that kind of law. That's why we have a new Center for Natural Law Jurisprudence, and we're trying to work with federal judges. A number of them are interested. What can we learn from this? And it's quite clear that they've become utterly strangers to a natural rights argument. And so it remains a live possibility that while the argument is cast in terms of the Commerce Clause, one of the Republican judges, such as Anthony Kennedy, will break away and find some ground for upholding Obamacare. Now, up until the oral argument several weeks ago, there was a serious concern in conservative quarters that Justice Scalia had already confirmed the grounds on which that the judges would back away from the judgment. And after all, it could be said, as I said before, that the main lines of jurisprudence are in place, and Scalia could rightly say that, now this is, we've done the jurisprudence, this is a political matter, you're going to have to defeat this politically by defeating Obama and putting in place the kind of Congress that would repeal Obamacare. But since the oral argument, that concern seems to have receded in part because Scalia showed himself to be deeply skeptical, deeply critical, quite firm on that main question to the Solicitor General: if you can reach this, tell me what you can't. Still, none of my friends who were arguing before the court in Obamacare claim any surety in knowing just how this will come out. They came away from the argument thinking, if we were going to lose, we'd have a sense of it. But we came away knowing that it's not clear we're losing. And I was pretty confident. I was telling Michael Weissman for us, he said that this strange gathering, you know, Scalia's are old friends. We've known them for 37 years. There was a Father Malcolm Kennedy was coming back to town after a retreat. They're going to get around the piano to bang out Broadway tunes. And we always loved that, and the Alitos were there, and we couldn't talk about the thing we all wanted to know. And I didn't know, Nino never showed, he's always joyous, but as I told Mike Weissman, he could just have that consolation that Charlie Rice reflects at Notre Dame. He says, don't worry, you're on the winning side. We'll win in the end. I said, yeah, never so often, Charlie, it's nice to get a victory along the way. But if Obamacare is struck down, I'm still, like Father Newhouse, I'm ever hopeful that we can be struck down. There's another serious political question arises as to what becomes of the rest of this sprawling, jerry-built construction called Obamacare. The central pin in this whole scheme is the mandate that compels individuals to buy the medical insurance. The assumption seems to be settled now that if the court strikes that down, that removes the central pin, then the insurance companies have been expected to give policies to everyone regardless of previous condition. There's no way they're going to afford this unless you force all these young, healthy people to buy the medical plans. It's going to be not tenable for the insurance company, so you're probably going to have to strike down that scheme of guaranteed issue, the obligation of the insurance companies to strike it down. But the justices in the oral argument were strained by the question of whether these parts of the bill were, as they say, severable from the rest. Can we simply strike down the mandate and guaranteed issue and leave all the rest of it in place? Justice Scalia asked whether people really expected the judges and their clerks to work through those 2,700 pages of a bill trying to figure out which parts were sustained. He invoked the Eighth Amendment, cruel and unusual punishment. You're inflicting cruel and unusual punishment on judges and their clerks if you expect us to do that sort of thing. But in the symmetry of these political divisions, the liberal judges seem to be inclined to uphold as much of the act as they could, but they're driven to avoid the impression taking hold that the act had been thoroughly, pervasively indefensible. There's something still laudable, something that deserves to be preserved. Yet it's entirely possible, conceivable, that a block of 5 conservative judges could strike down the mandate and then change places with their liberal colleagues. The conservatives could possibly see a conservative government for denying severability, while the liberals suddenly discover a serious interest in avoiding all the strains that come along with the remaining parts of the Obamacare have to be reassembled on a vast scale. In the temper of things, this doesn't seem to be a likely outcome, but it could be plausible, and it may be worth putting the question whether there could be an advantage for the conservative side for visiting upon the liberals the punishment of getting the result for which they've been so earnestly pleading. One of the keys to the problem may be found in recognizing that it was Massachusetts that was responsible for this rambling, sprawling form of construction. Massachusetts threw the proverbial monkey wrench into the whole construction by the simple expedient of electing Scott Brown. This made its way into the briefs because Brown's election prevented the Democrats from having the 60 votes necessary to overcome a filibuster. Well, that removed the possibility of pushing the bill through the Senate without an array of moderating the bill as it came through the Senate, or undoing the array of payoffs that came along with it. The elaborate system of payoffs comes crashing down if the system of paying for the whole ensemble is removed. So if the matter were, they had to go with the House bill. They couldn't count any longer on moderating it and shaping it in the Senate. You just had to go with what they had in the House bill. And then they had to add all these payoffs. And now if the central pins are removed, the mandate, guaranteed issue, now we have all these payoffs. And it may fall to the Democrats to figure out how are these payoffs going to be made? How are we going to reassemble the pieces? If the court strikes down Obamacare, the administration is obviously geared to trumpet a band of 5 Republican judges acting politically to deprive people of a measure that promised to deliver aiming care widely in the land. But the conservative majority could declare a posture of notable restraint here by striking down only the mandate and the guaranteed issue of policies. All the rest, with the generous provision of medical provisions, common and exotic, would still be there. Justice Scalia has made the point quite often that his colleagues should not make themselves into legislators by taking on the task of rewriting statutes. And quite apart from the insuperable task of judges working through 2,700 pages, there's a principal concern rooted in the very structure of government. Working through the bill in this way couldn't be the function of justices or their clerks. The judges don't have in their kit the standards for making these kinds of judgments for their political judgments on who would receive the benefits, who would receive the costs. Justice Kennedy worried aloud that the court would be flexing vast new judicial powers if it struck down the mandate and then created by indirection a large legal wreck that would bring so many of these companies to the edge of bankruptcy. And yet it could be argued that this was a wreckage produced by the Congress, but it sought to build a gargantuan edifice on terms so disfigured that they were unconstitutional. So the task of reconstructing the bill, facing what is unworkable in the scheme, facing the political costs that are insufferable, that's a task that should fall to the people who brought us this production. Now, why should they be deprived of the experience of salvaging the wreck that they themselves have created? No, but as they face this task of dealing with the wreck, one thing would be certain, that Obamacare, this is, I think, during the appeal, they had a deal with the appeal. One thing certain is that Obamacare, its conception, its parts, its cost, could not be pushed aside during this political season. It would have to be the Senate campaign. We could not avoid talking about it. It would force it upon us. It would remain the central issue of this campaign, regardless of how artful and resolute the Republican candidate happens to be. The battle cry, simple and ringing, could be a conservative principle, well-grounded, even for an expansive liberal purpose. And it was sounded in the argument before the court by Mike Carlin. If Congress wanted to mandate a national program of health care, there may be a way to do it, but it must find a path compatible with the Constitution and face the constitutional discipline of justifying to the public the taxes that they're going to be imposing in paying for the scheme, not to get around it through that device of shifting the cost to some other private parties and pretending it's not a public commitment. Now still, even the most appealing scheme promises to bring consequences unforeseen. The hospitals and insurance companies, faced with enormous costs, could be at the edge of bankruptcy. If the requirements are not repealed, the companies could ask for a bailout. But the Tea Party contingent in the House will surely not tolerate another bailout. Or their voters may not tolerate congressmen who are finally pressed to give in to the pressure when the administration fills the air with dire forecasts of people massively losing their jobs. So we may find that the political tensions here could be reversed. There could be tensions to blow up the Republican coalition in the middle of an election. And given the way the liberal administration seemed to play these matters with the help of the media, we may expect to see the blame shifted from the Congress to the court. It may be Scalia and company who are charged with responsibility for the wreckage that remains after the mandate is stricken and the rest of the enterprise begins painfully to implode. So the conservative judges may be inclined then in prudence to back into Edmund Burke's old dictum I've quoted often. I've quoted even to Scalia, that refined policy is ever the parent of confusion. They're not be overly refined about this. It may be better in a clean stroke to sweep away the entire statute and begin again, begin anew. And yet there are real temptations here, I must say, marked by the great line of H.L. Mencken, that democracy is a system in which people should be given what they want, good and hard. You wanted this, okay, it fell down. You put it back together again, you know. Some of us may be forgiven for being half ready to give them what they want, and scaring them with the possibility of giving them what they want may be the surest way of delivering them from their appetite to cling to the wreckage that remains. Well, we have no firm idea yet as to how this will come out. I'm getting vibrations, I hope are wrong, that it may come out the wrong way. It could go either way, so I hope that makes sense. I'm Mr. Romney, you better have something to say if this, not that, I hope that Mr. Romney and his crew are prepared for the worst. So if Obamacare is sustained, they should not take the constitutional judgment to mean there's something good and approvable in Obamacare. And that our job is to sustain the good parts while removing the others. I hope that Mr. Romney would take the occasion to make the case and summon the country for the repeal of Obamacare by a new administration in Congress. It would be a time for the leader of the Conservative Party of the country to stop relying on the courts to do the political work, to do the political work himself by awakening the country to the fact that this scheme of Obamacare, extending the reach of the law, threatens to remake the political order and the terms of principle on which we live together as people. I'd rather he would be doing things like this to ask, what kind of a people have we become? Is this the kind of people we've become? Are we the kind of people who would actually prefer to have fewer doctors and nurses if they would not perform abortions? Fewer schools if they would not endorse the contraceptive ethic? Are we really willing to have people, the government deny to people life-saving care that they're willing to pay for themselves out of a system of rationing? Are we really willing to settle here with a government that now has the leverage now over our lives to force these kinds of decisions? This would be a moment for Mr. Romney to crystallize for the country the question of the kind of people we think we are. And then summon the voters to do the work that must be done. Okay, thank you. Woody always say, I'm sorry I can't leave you with something positive. Would you accept 2 negatives?